Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.
Hello, and welcome to today's Savant Live webinar. Thank you so much for joining us. Today, we're going to be discussing preserving generational wealth. My name is Alaina Davalos, and I'm a wealth transfer advisor here at Savant. Joining me today is financial advisor Evan Kuykendall.
Hey, thanks, Alaina. I'm glad to be here. This topic is an important one to address, and a lot of people may not be thinking about some of the tax implications, how we do certain things, and what to teach to the next generation. So hopefully we can help you start to think about some of these things today as we just start to discuss.
So Evan and I were really excited to present on this subject because it's a really buzzy topic. Everyone is talking about generational wealth and the great wealth transfer that's about to happen. So we figured why not give you some pointers to help you participate in this movement as intelligently and tax efficiently as you can. So, what is generational wealth? Technically, it's wealth that's being passed down at your death, generally to your descendants or heirs. However, generational wealth is also a concept that hits home to a lot of families because it represents their legacy and their success. It represents this idea that you worked hard enough during your life that you'll be remembered by your grandkids for years and years to come because of this financial gift that you've given them. No, it's the epitome of success in America. And so, just a quick overview of our conversation today. We're going to start by talking about estate planning, one of the best tools out there to safeguard your legacy for those future generations. We'll then move on to talking about lifetime gifting, as well as some ways to maximize the amounts you can pass to future generations by making some savvy tax decisions. And lastly, we'll finish with a discussion on passing down not just money and assets, but also the knowledge that comes with managing great wealth, as well as some tips on how to preserve the integrity of the funds that you're passing down without creating the notorious trust fund baby. So let's delve into some of those estate planning tools that you can use to preserve your wealth for future generations. And just a reminder, estate planning is based on state law. So while we're talking about some general concepts today, make sure you work with a local qualified attorney in your state of residence if you want to implement any of these ideas into your estate plan. So Evan might disagree with this statement, but I'm going to say it. Estate planning is the best tool that you have to preserve your wealth for not just your children and your grandchildren, but as far down your family tree as your bloodline will go. If it's right for your family and your set of circumstances, an estate plan that establishes trust for your descendants is the best way to preserve generational wealth. The sort of trust I'm going to be talking about today is referred to as a descendants trust or a cascading trust, because once you put assets into the trust, either during lifetime or at death, the assets will stay in trust for cascading generations. So first to your kids, then your grandkids, and so on. Another term that you might be more familiar with is a trust fund. That's right. We are going to be talking about how to create trust funds for your kids. A lot of times, these trusts get a bad reputation because they're seen as only for really wealthy people or as controlling assets from the grave. This is a phrase or a worry that I usually try to avoid because it has a pretty negative connotation. No one wants to be labeled as a control freak. But hear me out. If a trust works for your family, you can protect assets for a possible unlimited amount of generations from divorce, creditors, and possible estate taxes. How long the trust lasts, again, depends on state law. It can range from 90 years to an unlimited number of years in some states. And generally, most states are only getting more and more flexible with their trust law. So, why doesn't everyone do this? Why do we only typically associate trust funds with the wealthy? That's a question I get from a lot of clients when we start talking about these descendants trusts. For starters, a trust can be more complicated to both set up and administer. These descendants trusts are often established under your will or revocable living trust, so your estate planning documents. When making these documents, you generally will have more decision making you have to do. You have to pick a trustee. You have to pick distribution terms for the trust, meaning when income and principal can be distributed out of the trust. And you have to pick how long the trust is going to last. But on the flip side, you can leave your legacy, the assets that you've worked so hard for, to your descendants in this protected vehicle that can protect that wealth from divorce, creditors, and again, possible future estate taxes. I tell our clients all the time these descendants trusts can, with good management and not too many family branches spawning off, last for centuries. So I don't want to get too bogged down in trust formation today because it is such an advanced topic in and of itself, but I will give you a quick overview. You name a trustee to manage the trust on behalf of the beneficiary. You can give your trustee as much or as little guidance, control from the grave, as you feel comfortable with. If you do decide to set up these trusts for your descendants, they're most oftentimes, like I said, created under your will or revocable living trust and are only effective at your death. That means those documents and the decisions you make in them can usually be changed at any time. In those descendants trusts, though, however, they're called testamentary trusts, created under your last will and testament. They do become irrevocable upon your death. If, you stop and think this is not something that you would want, I always recommend having a good estate plan either way. The other option that you could implement in your estate plan, or you may already have, would be to make outright distributions to your beneficiaries. This is an easier plan. I won't lie about that. You say in your will, I leave 50% of my estate to my son and 50% to my daughter, outright and free of trust. You name both your son and daughter as 50% beneficiaries on your 401k and life insurance. Easy peasy. The downside to this outright gifting, though, is that once those inherited assets are freely gifted to your beneficiary, they have no asset protection. Your daughter can go and spend her entire inheritance on a Lamborghini and leave nothing to your grandchildren. Your son could commingle his assets with his wife's when she leaves him in the divorce, takes all of his money. Again, there's nothing left for your grandchildren. Once you're gone, that money could very easily be gone. And so what we see is that those outright gifts typically do not lead to generational wealth. The other thing that is important to consider, and this applies to all of estate planning, but especially to trust formation, is the best way to preserve generational wealth and your assets generally is to not lose it at your death. So we all know the horror stories of friends and even our own families that when someone passed away without a good estate plan, it created some tension between family members. Sometimes that tension gets so bad, someone will go to court. And let me tell you, once lawyers, lawyer myself, and the court get involved, things can get really expensive. And all of those funds, your lifetime savings, your legacy, can quickly be eaten away by legal and court fees. And I will say, when I've seen an estate plan gone wrong, Most oftentimes, it was because the assets weren't coordinated the way they should have been. Spouses didn't own property as joint tenants with rights of survivorship, meaning they had to probate the will. Some people never updated the beneficiaries of their 401k after a divorce, like my father, looking at you. And an old spouse received that asset instead of the kids. There's a lot of issues that can come up with the different assets. So honestly, the best place to start, again, whether you're updating your estate plan, whether you've never had one, or whether you're going to look into doing these descendants trusts, is to start with a good net worth statement and make sure that every asset you have is coordinated in terms of your overall plan. Take a look at where all of your assets are located and then work with your professional advisors to determine how they're going to pass at your death. Getting organized like this not only helps to avoid expensive issues at your death, but if you've taken my previous advice and included these descendants trusts in your estate plan, you've got to make sure that those assets, that those trusts are fully funded, meaning all of the assets, or at least the ones you pick, from your net worth statement are pouring into those trusts at your death. And the best example I have of this, the easiest to understand, is life insurance. So let's say you've got a life insurance policy, your spouse has predeceased you and you have those two children. The beneficiary of your life insurance could be my children. You say, okay, I'm going to leave 50% to my son, 50% to my daughter of my life insurance policy. However, if you've got a will that created these descendants trusts at your death, you want to make sure that the funds from that life insurance policy don't go to your kids outright. You want to make sure they pour into those descendants trusts. So what you could do instead, you could name my estate or my revocable living trust as the beneficiary of that policy. You could go a little bit deeper even and say, I name the descendants trust created under Article 6 of my will as the beneficiary of this policy. That makes it so that policy pours into that trust and that asset is protected. I usually tell clients that getting their estate planning documents is getting them drafted and signed is step one. Once you have your will, your powers of attorney, possibly a revocable living trust signed, then you've got to move on to step two, which is aligning those beneficiaries. Again, when you've got that net worth statement to go off of, you're in a lot better place to get this done. A lot of people assume that a will controls everything, but that is not the case. A beneficiary designation on your 401k will overrule what's written in your will, even if that's not what you intended. Or another scenario I see often, let's say you loaned your daughter money to buy her first home. Unless you have that agreement in writing, there's no guarantee that your daughter will pay your estate back for the money that she borrowed. And so that could lead to discrepancies between how much your children receive. Lots of these little inconsistencies can lead to outright gifts that you didn't intend, and you end up with an unfunded descendants trust. So let's say, though, you did what I suggested, and you incorporated this descendants trust into your will. You want to create a trust fund for your descendants. Now what? Well, let's go to step two. Let's make sure that those assets that aren't covered by your will are still going to pass the trust. Like I mentioned, change those beneficiaries on your life insurance. Go get a new beneficiary designation form. Write down the trust created under your will instead. Your personal residence that you own as joint tenants with rights of survivorship with your second spouse. Nope, we don't want that one because that piece of property would pass directly to that new spouse instead of passing under your will. Generally, with these descendants trusts, with creating these trust funds, you can put any asset into it that you own. Some just take more coordination than others. There is one exception, and that, of course, is qualified accounts. So, qualified accounts have special rules because of the special income tax treatment that they receive during your lifetime. Evan can confirm, we could spend hours going through the different income tax ramifications of naming certain beneficiaries on your qualified accounts, which includes your 401ks, 403bs, all sorts of IRAs. So you can name a trust, you could name that descendants trust as a beneficiary of a qualified account. The trust has to qualify as a see-through trust, meaning you have to be able to look at the trust terms and see who the beneficiary is, the individual. The trust also must specify what happens to the RMDs of that qualified account. RMD stands for Required Minimum Distribution, which is the amount that must be distributed out of that account after the initial account holder turns 73 and a half. So the trust must say whether the RMD is distributed outright to the beneficiary, which is called a conduit trust, or whether that RMD is held in trust for the beneficiary's benefit, and that's called an accumulation trust. The type of trust will determine how long this qualified account can remain qualified after the death of the decedent, meaning how long does the trust or the beneficiary have to convert that account into a brokerage and pay all the income taxes on it. Again, this is one of the more complicated aspects of estate planning, and oftentimes you may have to decide between tax efficiency, getting the best income tax outcome, versus asset protection, which is protecting your assets and creating generational wealth. Because sometimes you can only get one or the other. A trust may create that generational wealth, but your beneficiaries may pay more in income taxes. There's a lot of balancing that comes with qualified accounts and trusts. So again, make sure you work with a qualified professional who is familiar with these concepts and can help guide you in your decision making. I have a few more notes on trust funds that I just want to go over quick before I hand the mic back over to Evan. And the first thing is going to be picking your trustee. So there's this theory out there about the 3-generation rule of wealth that refers to the common belief that most wealth accumulated by the first generation of a family, so let's say you, is often gone by the time the third generation inherits. So if you leave a trust fund for your kids, by the time it gets to their grandchildren, it'll be gone, either through mismanagement or too many branches of your family tree. There's a few reasons. One of the steps that you can take to avoid that issue is to put some good thought into who you name as the trustee of the trust fund. Let's go through your options. The first is an individual or a family member trustee. So someone close to you, someone that you trust. With the right distribution provisions, this trustee could even be the beneficiary of the trust themselves. You could create a trust for your son's benefit and name your son as trustee, provided he's limited to the health, education, maintenance, and support standard of distribution. That is not just a fun acronym I came up with, that comes directly from the tax code and the IRS. So setting up what's called a beneficiary controlled trust, meaning the beneficiary and the trustee are the same person. This is the easiest option because you know your son. You hope you've instilled enough financial wisdom in him to manage this trust fund well and to make good decisions. So that usually works for the current generation. You know your kids, you maybe even know your grandkids by this point. Are they financially mature enough to not only understand what they're doing financially, but also to understand the significance and the opportunity that you've gifted to them? Pretty much, do you think they will go and blow their trust fund or not? In some cases, you may never want a beneficiary to be the trustee of the trust. For example, if you have a child with addiction issues, that's usually not a good trustee. You know what they're going to do with that money as soon as you are gone. Another scenario where a beneficiary of the trust does not usually make a good trustee is with a blended family. You may create a trust for your spouse who is not the parent of your child so that you can take care of your spouse during their lifetime. And then whatever funds are left eventually go to your kids. If you name that spouse as trustee and give them access to income and principal, it could be very easy for them to drain the trust, leaving nothing for your kids. Usually, in those situations, a third party trustee, such as a friend or a sibling, is better. You do also always have the corporate trustee option. Corporate trustees are great because they will preserve the trust fund for future generations and make very conservative distributions. However, corporate trustees do charge a fee for their services, so that's not always worthwhile, but it is always available. And another option you have is co-trustees. Let's say you do have a child with an addiction and they'll never, as far as you're currently aware, be at a point to manage their own trust, but you still want to be able to support them. You could name that child as a co-trustee with a sibling that they respect and trust. That way you always have a security blanket there to make sure the trust isn't spent on the wrong things. And I will say, choosing trustees can be the hardest thing for clients that I've worked with to select because it's a very personal decision. There's a lot of thought that goes into it. And with these descendants trusts, there can be a lot of ramifications because these trusts last forever. The other major decision that you'll have to make if you incorporate trust into your estate plan is, when can assets come out of the trust? When can this money be spent on your beneficiaries and how? You have full control over that, so long as it's not an unethical distribution standard or against public policy, you can dictate all of the terms of the trust. When I was in private practice, I was a big supporter in trusting your trustee. What that means is giving them the maximum amount of flexibility to make those distributions. I would advise clients that an independent trustee, meaning someone who isn't benefiting from the trust, could make distributions of principal and income for any reason. On the opposite side, an interested trustee, who's usually a trustee and beneficiary, that beneficiary controlled trust, they could make distributions for the HEMS standard again: health, education, maintenance, and support. With that IRS standard, that's what gives these trust funds asset protection from federal estate taxes, which I'm going to talk about in a couple of minutes. You can give as much binding guidance to your trustee as you would like. You could say, hey, distribute $2,000 a month to the beneficiary starting when they turn 25. When they turn 30, they can get $3,000 a month, something like that. I'm not so fond of strict distribution schedules like this because while $2,000 a month is a lot of money right now, it could be pennies 100 years from now. It could be nothing. Your trust, the other thing is your trust could be earning $10,000 a month in income, but your beneficiary only gets two. So now the trust is paying at a higher income tax rate. That may not be the result you wanted either. If you're comfortable with it, trust your trustee and let them figure out principal and income distributions based on the needs of the beneficiary at the time. The other thing that you can do, and I highly recommend this if you're going to do descendants trust, create these trust funds, is you can provide guidance. My trustee may do this. My trustee may do that. I request, but do not require that my trustee make a distribution for my beneficiary's first wedding. Not the second, not the third, but the first. I want my trustee to encourage my beneficiary to sustain their own lifestyle without relying on the trust. Language like that, it's guiding, but not binding. And so, one last word of advice before I let Evan in, let your trustee know either in a separate writing or by having a conversation how you want the trust fund to be spent. If you want your beneficiary to travel the world and live their best lives, then tell your trustee that. Tell them to support that lifestyle and that ambition. If you're more interested in creating generational wealth, creating a safety net for your descendants, again, tell your trustee that. Tell them that's your preference. And that'll go a lot further than you pass away and your trustee receives a bunch of, legal terms hidden in a 60-page document. So just some other things to think about. Always consider open and honest communication if you're going to be using descendants trust or trust of any kind. So I've done a lot of talking about estate planning and trust funds. I think it is now time for Evan to talk to us a little bit about lifetime gifting.
Sounds good, Alaina. Thank you for that. I'm excited to be back here again. Let's see. Let's shift our focus to gifting now. More importantly, on the income tax side, I know you can do the estate planning later, Alaina, but I like the income tax part of things. I think a great place to start here is why we're gifting in the first place. Is it to leave a legacy with your family or your community? Or is it more important for you to make an impact now with your time and money? One of the most common questions I get asked is, do I have sufficient capital to live off of for the rest of my life? My initial answer, like most answers of mine, are it depends. There's a multitude of items to consider when trying to get to the bottom of this question. What are your personal goals outside of the gifting that you want to accomplish throughout your lifetime? Do you want to buy a second home? Is there boats that you might want to buy? These all play a factor into this. When do you want to retire if you haven't already? If you're gifting to charities, how much do you plan on gifting to your kids or your heirs, or do you want to do that at all? I know some people have the die with zero mindset. That also plays a factor into this question. One of the best ways you can get down to the bottom of this and answer the question yourself is to talk to a financial advisor. While we never know the future and cannot predict the future, we can certainly walk you through exercises that can get you to the bottom of this question. Now I want to move to talking about timing of gifting. We call gifting now gifting with warm hands. I like to talk about this at a higher level. First off, I like to say that planning drives strategy, or your financial plan dictates your investment strategy, which for most people will be completely different from your neighbor down the street. Someone that's 25 will have vastly different needs and risk tolerances than someone in their 60s. Gifting with warm hands can allow heirs to implement their own financial process and plan sooner. So let's look at the right hand of the screen right here at a little example I created. Say two families want to set aside $500,000 to gift to their kids. One family, family one, decides that they will gift to their kids now. They will start gifting with warm hands and allow their kids to make their own financial decisions with that money. In this case, the kid from family one decides to put it into an all stock portfolio, while family two holds back the $500,000 in a separate account and invests it in 60% stock in their portfolio currently. We can look at this a bunch of different ways, but mathematically, family one's way of doing things is better. They have almost $500,000 more at the end of 20 years because they let their kid decide what they needed to do with their money and understand his risk tolerances, his or her risk tolerances. But stepping back, because math is not all of it, it's all about emotion as well. There's other factors such as financial readiness. Fear of spoiling the kids is a big one as well, or deterring work ethic and more to consider when gifting with warm hands. The best way to think about this is to talk to your spouse and come up with a conclusion on what you guys think is best. There isn't a right or wrong way or decision to decide about this. It's all up to your values and your beliefs. Your financial advisor can also weigh in on this topic, but ultimately it's up to you and your generational wealth to decide how to do that. Alaina, can you move to the next one, please?
I can.
Thank you. So now we talked about why we gift, when we gift, and now we're going to talk a little bit about how we gift. And I want to take a step back and say that from a 30,000-foot view, there is 3 places your money can go. You can spend it, you can gift it to a charity or your kids, or it's going to go to the taxman at the IRS. Using these vehicles on screen right now, we can help lower our tax liability while still hitting those goals of wanting to gift. Many of these vehicles seem super complicated and they sound crazy at first glance, but once you understand how they work, you'll see that the benefit of using them instead of gifting outright cash is much better in the long run. So let's look at a couple ways of doing that. One of the most common vehicles we use for gifting is the Donor Advised Fund, or the DAF for short. The Donor Advised Fund acts as a private foundation where contributions are tax deductible up front. You maintain control of distributions to charities, meaning you can gift the assets within the Donor Advised Fund at any time in the future once they're in the Donor Advised Fund. The DAF also allows you to gift appreciated stock or stock with huge taxable gains into it to relieve yourself from paying capital gains if otherwise sold. We see many people with shares of Meta, Google, Tesla that have huge capital gains that they've had for 20 years. They're able to hit their goal of gifting while also sidestepping the tax burden if they move those shares into the Donor Advised Fund.
Can I ask you a question, Evan?
Yeah, of course.
Is there a reason why you would use a donor advised fund over a private foundation?
That's a good question. I think me and Alaina would have to have a discussion about that because I think you're more on the private foundation side of things, and I would probably recommend the DAF more. But I think we could go through it and talk through. The Donor Advised Fund is great for gifting to charities. So that was kind of my next point. It's not awesome for gifting to individuals or friends or family. These Donor Advised funds or grants have to go to a 501c3 charity. And that's a big note to add. And lastly, we can lump sum multiple years of contributions to help you itemize your deductions. I think that's also something key to look at and a big pro to the Donor Advised Fund versus a private foundation. Let's take a look at the visual though, because I think this will start to show it in a better light. So you're the little green circle up top, and the Donor Advised Fund's the blue circle, obviously. We have the charities down below. So what you'll do is donate types of assets. So cash, stock, bonds. You can donate crypto, business interests, and other assets to the Donor Advised Fund to get the immediate tax deduction and then grant that money to 501c3 charities anytime in the future. Note that you don't have to pick just one charity and stick with it. So if Red Cross is not your thing, you can spread the wealth around. I think the Donor Advised Fund is a great place to start gifting when you still have business or if you have high income tax years. And let's look at a simpler way to gift stock. You can also gift stock without the use of a Donor Advised Fund to a qualified charitable organization. You don't need anything else fancy. You can just go from your brokerage account or whatnot straight to the charity. This allows taxpayers to avoid paying long-term capital gains tax on low cost basis stocks. Again, without the use of a Donor Advised Fund. The deduction is subject to a 30% AGI limitation. So for example, if your AGI is $100,000, the max stock donation deduction you can take is $30,000 for that year. So that was a lot of words. Let's throw some numbers on the screen here so I can confuse you guys a little bit more. In this example, we own ABC stock. It's had record returns for 10 years. The fair market value currently is at $50,000, and we bought it for around $5,000. So awesome return. We have the long-term cap gains rate at 15%, and then our tax rate is 24%. We have two options when we're wanting to gift here. Option one would be to sell the ABC stock and then donate the after-tax proceeds. In this scenario, we still have to pay long-term capital gains tax from the sale of the security, and then we're donating the cash. And so our tax savings is $3,600. It's good, but we could do better if we already know that we're going to gift the securities, leading me to option two, which is contribute ABC stock directly to the charity, the 501c3 charity. In this instance, since there's no sale of the stock, we don't have to pay any long-term capital gains on it, and we can donate directly to charity, saving us $12,000 in tax savings. Lastly, I want to take a look at how we can gift from our IRAs. So as Alaina previously mentioned, RMDs, or required minimum distributions, start at age 73. Basically, the IRS thinks that they've allowed you to defer this money for way too long, and they want their tax money now. And so one way around this is we can use what's called a QCD, or a qualified charitable distribution. It is an excellent strategy for people with large IRAs that are already planning on gifting. You can gift up to $100,000 a year if you're over 70 and a half to the QCDs. Note that this is not the same age as that RMD at age 73. And so we do have a 2.5-year gap or so where we can front load some of these QCDs. The great thing about a qualified charitable distribution is the amount donated is excluded from taxable income, which can help lower overall tax bills while also lowering your RMDs for the future. I do want to make one note because we've had this come up before. Make sure to tell your tax professional about the QCDs that you've done throughout the year, because they will not be identified on the Form 1099-R. It just won't show up, so please let your CPA know about these items. Now, I'll throw it back to you, Alaina, to talk through gifting through an estate tax perspective.
Thank you. So I do want to briefly touch on federal estate taxes. This tax applies to all gifts, whether those gifts are made at death via your estate plan or during your lifetime. You can gift up to $19,000 this year to anyone every year without incurring any tax liability. If you exceed that $19,000 amount, or whatever it is the year of your gift, that transfer is subject to estate taxes. However, you won't actually pay estate taxes until you exceed your federal estate tax exemption amount, which again for this year is $13.99 million per person. So $19,000 you can gift, no strings attached. You exceed $19,000, you can go up to $13.99 million without having to pay any taxes. So that $13.99 million, again, can be done during lifetime or at death. If you make transfers during your lifetime, it eats away at the exemption you have remaining at your death. And that exemption is doubled for a married couple, so about $28 million. And what that means realistically is that this topic doesn't apply to most people. I wish it did, though. I wish all of our clients in estate tax problem. So I do want to touch on it briefly, but it's not going to be a big topic as it relates to generational wealth. So the federal estate tax exemption amount, meaning how much you can pass without paying taxes, has fluctuated throughout history and is currently the highest it's ever been. That number is controlled by Congress, so it can change at any time. And the number that I just mentioned, $13.99 million, It is already currently scheduled to sunset at the end of 2025, probably down to about $7 million per person, again, unless Congress changes it. The exemption amount is how much you can transfer without having to pay taxes. What you should start to consider doing is lifetime gifting. You saw in Evan's example that when you gift with warm hands, when you gift during life, those assets grow, will grow greater estate tax free once they're outside of your estate tax or once they're outside of your taxable estate. And so right now, with this historically high exemption amount, it is a use it or lose it. So once the exemption decreases from about 14 million down to about 7 million, you can't get that extra gifting amount back. However, you also won't be punished. So if your estate looks like this and you're concerned about estate taxes, that's when we start talking about doing lifetime gifting for estate tax purposes. Let me just give you a quick example. Let's say you want to gift $8 million of your company stock to your child. If you make this transfer during 2025, you won't owe estate taxes. You also won't be punished when the estate tax sunsets. That $8 million that you've given to your child, no matter how much it grows, you won't pay additional estate taxes on it at your death because you gifted it during life. However, if you wait to make that transfer in 2026 and the exemption decreases to $7 million per person, you would have to pay estate taxes on that $1 million overage. And you also would pay estate taxes on anything that you passed at your death as well, because you used all of your exemption amount during lifetime. There are also state estate taxes and inheritance taxes. The difference between an estate tax and inheritance tax is that the estate tax is paid by the estate of the person that died. Assets are only distributed out of the estate after the tax is paid. With an inheritance tax, the beneficiary who receives the inheritance pays that tax personally. And you'll see that little bitty Maryland right there does have both. So if you are a Marylander, please discuss this with your advisors. And however, just like the federal estate tax, these states do have varying exemption amounts, but unlike the estate tax, which is a flat 40%, many of these states have progressive rates. And then the last thing that I want to emphasize here is that the state estate tax is imposed on top of the federal estate tax. You may get a deduction on your federal estate tax for certain state estate taxes, but usually you end up paying both once you've gone past those exemption amounts. If you do think that it would be worthwhile for your state, you're concerned about estate taxes, and you think doing some lifetime gifting for estate tax planning would be beneficial, I just want to go over the steps of gifting with you, as well as reiterate the benefits and risks. So the first step would be to set up an irrevocable trust. Decide what sort of trust, who the beneficiaries will be, sign the trust agreement. And side note, you can gift assets outright. You do not need a trust to do lifetime gifting. However, this presentation is about preserving generational wealth. And as I've already gone over, a trust is the absolute best way to do that. So next, you would prepare your assets for transfer. You may need to get approval or permission from business partners, spouses, do different real estate deeds, things like that. Get your ducks in a row. Then transfer the assets. Sign the deeds, move the accounts, assign the business interests. The day that those documents get signed or the assets actually get moved is the day that you'll need to provide a value for, which is the fourth step. So valuations. Once you have a date and discernibly gifted assets, you start working on valuations. The IRS requires you to provide adequate disclosure. What that means will depend on the asset itself. If you have real estate, the opinion of a realtor, if you have a business interest, a business valuation company, something like that, a third party who's a little bit more neutral, not as biased as you might be. So last, file those trust agreements, the transfer documents, anything related to these transactions with a 709 gift tax return. The gift tax return is due on April 15th, tax day, of the year after the gift is made, along with your personal income tax return. You can file an extension if you file an extension for your personal returns to October 15th. The best advice I will give you is do not wait until September of that following year to try to get valuations and appraisals done, because all of those companies will be very busy. A timely filed 709 starts a 3-year statute of limitations for the IRS to contest the values of the gift that you've made. And in exchange for taking these steps, you'll not only use the historically high estate tax exemption, you'll freeze the value of any growth of those gifted assets, and you'll be providing additional creditor protection in the event you're ever sued, your kids are ever sued. These trusts have a whole range of benefits. Not to be too cliche, but with great reward does come some risk. So first off, please know that this is usually not a cheap endeavor. And if it is, something has gone wrong. You want to make sure you work with an attorney who specializes in this area of law. You will pay for that expertise. Same goes for the CPA who files your return and whoever you get to appraise your assets. Also, generally speaking, assets that are gifted do not get a step up in basis for income tax purposes, which is why it's important to analyze which assets you're gifting before transferring them to a trust. And lastly, your gift tax return can get audited. The IRS can come back and challenge the values that you've used. Anytime you're audited, your legal expenses challenging it can add up. So the last thing, this is again, just to reiterate that this is lifetime gifting for estate tax purposes is very complicated. So what I want to show you is called the ABCs of estate planning. These are all the acronyms for different trusts you can set up during your lifetime, different tools we use for gifting. Very complicated. Please do not go down this road without a good team of support. There are very real tax consequences to lifetime gifting that you may not be familiar with, and that can take a lot of analysis to work correctly and tax efficiently. Another side note, these trusts are usually much more complex while you're alive. The descendants trusts that I talked about earlier that are created at your death, those are much easier to understand and administer once you are no longer with us. So don't let complicated estate tax planning defer you from looking into creating those descendants trusts at your death.
Thanks, Alaina. I'm gonna have to let you teach my future kids those ABCs. I'll focus on the normal ones.
No problem.
Yeah, so those a lot better than I do. So let's move on to asset allocation and location and why these are so important when talking about generational wealth. I think for starters, it's important to understand the difference between a stock and a bond when looking at allocations. A stock is just a partial ownership of a great company, and a bond is loaning money to great companies and the government. Asset allocation is the most effective means of capturing market returns. Many tend to focus on less important factors like stock selection or market timing or listening to the news, when academic research tells us that stocks have a much higher return than bonds. We do need bonds. They're used as our risk reducers, allowing us to have access to capital in times of micro downturns and have some steady income on the side. When we look at building out your portfolio, we think asset allocation is so important, but we're doing that at a portfolio level. So if your total portfolio is 70% stock and 30% bond, it doesn't mean that every account within that portfolio will be a 70% stock portfolio or account. So when thinking about generational planning, you should consider having different allocations inside different accounts under the umbrella of your portfolio. For instance, if you have a trust that you're not going to use for a long time, I know Alaina mentioned a couple that we talked about, you might want to have more stock in there so they can grow for kids and grandkids down the road. Now, on the flip side, maybe your brokerage or joint account that you use for your daily living needs, we probably don't need to be 70-30 in there either. We probably need to be more like 50-50, have a lot of cash on hand for liquidity needs and withdrawals for daily use. And so when you're thinking about asset allocation, don't think about it at the account level, think about it at the portfolio level. And Alaina, can you move to the next slide, please? And making sure that that is consistent. And so a big question is, when should you change your asset allocation? It is a total, again, depends type of question. Asset
You're
allocation
going to be a lawyer
location.
at the end of today. I've been
Oh,
with
I
all your,
know.
it depends.
A lot of it depends on your specific factors that you have. So lifestyle goals, risk tolerances, your time horizons as well. Things might also change your asset allocation. Maybe it's a life event like retirement, or maybe you just can't stand the volatility in stocks anymore. But I think the best way to dive into it and get a number is to talk with a financial advisor, have them walk you through their process or our process, and find an allocation that's right for you. Now I'd like to switch gears a little bit and go to tax efficiency.
Tax efficiency, my favorite topic.
Oh, yes. Here at Savant, we are very worried about the tax man and very cognizant of him. We try to be extremely tax efficient. And so on your screen here, you have 3 buckets with different taxable accounts. The Roth IRA, the assets grow tax-free and withdrawals are tax-free. So we're going to want to have our highest grossing stocks in there, or our stocks that we think have the highest growth potential. So those are things like small cap value stocks and emerging markets. On the flip side, we have traditional IRAs where assets grow tax deferred, but then on withdrawal, they're taxed at ordinary income tax rates. So ideal asset classes for this are high ordinary income, the lowest expected growth, and high distribution rates. And so those are things like taxable bonds and REITs or real estate trusts. Then we have the fun side, the taxable side, where assets are taxed and sold at capital gains rates or ordinary income for some other things. But we'll just focus on the capital gains for now. The ideal characteristics for the taxable bucket, is low ordinary income and a high growth rate because it is taxed at capital gains rates. So examples of this are municipal bonds or US large cap stocks. Alaina, can you go to the next one for me? And so you saw muni bonds in the last slide. We use muni bonds all of the time. An example I like to use is someone had just retired. They made $250,000 a year, so they had a really high income. And then they came to us and we saw that their individual account held a bunch of municipal bonds. Again, individual taxable account. It doesn't make any sense anymore because muni bonds don't have taxes associated. We don't have much taxes now that we're retired. So what we would do in that situation is let the munis mature in the taxable account, and then we'd replace them with corporate bonds within their other IRA over here. And then we would start putting stocks inside the taxable account. Also, just a note that here at Savant, cash is non-managed, non-billed, and held in a 1.5 yielding fund. And so we can use this for DCA investing schedules that you might have when retiring. I think there's so much granular stuff that is went over, but I think these are the small things that add up to generational wealth over time. So now I'd like to move over to passing down knowledge. Alaina might get mad at me for this real quick, but estate planning in the US is taboo in nature. It's at a high level, it talks about death and money. two of the touchiest subjects. We have deeply ingrained cultural beliefs about self-sufficiency and the American dream. I mean, the US has long championed the idea that if you work hard, you're really good at what you do, you can do anything you want. Inheriting wealth completely contradicts this notion, making it an uncomfortable topic for families to talk through, meaning many families avoid even talking about their estate plans at all or how the estate was made in the first place. I'm not telling you to go tell your family members how much money they're going to get or the dollar amounts associated with it. I am nudging you, though, to start conversations with your family. Talk about the basics of your estate plan, as well as being open and honest with them about how you got into the situation. Here you'll see an estate and trust administrator guide. Alaina goes through this amazingly. I think it's just a great place to store a ton of information, and it's something that we go over with a lot of clients. But it helps you stay organized. It goes over personal property memorandums, ethical will statements, funeral and burial arrangements, because a lot of times families have no idea where wills might be stored or even where bank accounts or investment accounts are at. And I like to say, side note, Alaina might like this. I didn't tell her I was putting this in, but we're not just here for the financial aspect of passing down knowledge and estate planning. We try to give you actionable advice on other issues. For example, Alaina always tells people about the legacy contact on your iPhone. So if you have an iPhone, you can go into the settings and put in a family member that can access your phone after death, so you don't lose videos, photos, all kinds of data that you want to see or that your family would like to see. That's one of my favorite things Alaina says.
I do like this. I'm glad to hear that you are paying attention when I'm talking
Hey,
about things. Thank you, Evan.
yes, yeah, of course, of course. I would never not pay attention. Come on, it's
Thank
so
you.
interesting. I like to think about passing down knowledge in two main categories. There's short-term knowledge, and then there's long-term knowledge, or short-term things that you can do, and then long-term things that you can work on. In the short term, we want to focus on basic blocking and tackling, to use a football analogy. Understanding basic financial skills like how to use a credit card, how to safely use credit, create a budget. What are the basic account types that you can have? And maybe an intro to investing. Along the way, I think it's great to share experiences you've had with your heirs about different investments. Maybe your younger child is into crypto. I wouldn't shoot them down and say that's the worst investment ever. Instead, I would try to ask them questions like, how'd you get into crypto in the first place? Or when do you think you sell? Do you have an exit plan on this crypto holding? Even if you don't agree with the investment, they are gathering valuable information and experience as a young investor, whether they lose money or not. The second category, or the long-term category, this encompasses values and beliefs that have been passed down through generations, through families. I think the best way to pass down knowledge is by practicing what you preach with your heirs. Continue to follow the values, habits, and beliefs that led you to this point in life. I just heard one of the most interesting, again, another side note, one of the most interesting ways to long-term pass down knowledge through an allowance. So this family gave their kids an allowance, but they gave it in 3 envelopes, and 30% had to go to charity, 30% had to be saved, and then 40% they could spend the rest. And I think it's just a great way of instilling young values in young kids on what their family believes, and it leads to generational wealth if they continue that. I think one of the most important aspects of long-term passing down knowledge, if you want to call it, is building out a team of experts or professionals. So this means a financial advisor, a tax prepper or a CPA, a lawyer like Alaina used to be. I'm glad she's on our side, by the way, and anyone else that you might need. Leaning on your professionals opens you up to doing things that you like to do and that you're great at. This is especially important for heirs receiving inheritance and they never really had money before. They don't know what the first thing to do is. A good team of professionals will work together and create a holistic strategy that encompasses all your goals and wishes. Bringing this back up a little bit, here at Savant, wealth management does not just entail investments. It is the engine that drives the car, but it isn't the only thing we do. We look at wealth management in a holistic manner to create a cohesive plan, as well as work with your other professionals to give you the best experience possible. So now I think I'm going to toss it back to Alaina to talk through some responsibilities.
So, thank you, Evan, for talking about passing down that knowledge because you're right. It is a very sensitive subject for a lot of family members. And I cannot emphasize this enough that if you feel comfortable, please have open and honest conversations with your kids, with your beneficiaries. The more openness, the better scenarios you end up with. And so, switching over to sort of a moral and fiscal responsibility, I mentioned this earlier, the three-generation rule of wealth, that by the time the third generation rolls in, they're not working, they're lazy bums living off the trust fund. This is not what you had in mind when you created these trusts. So, how do you avoid that? If you haven't created a very strict trust, to avoid a trust fund baby, which essentially means preventing someone from becoming entitled or financially irresponsible due to inheriting this large sum of money. Focus on instilling strong work ethics, financial literacy, and a sense of responsibility in your children from a young age, especially if you plan on leaving them a large inheritance. And again, constant reiteration, openly communicate with them about the existence, the conditions of any trust fund. Talk to them about that as they mature. Your 18-year-old might not be the right time, but by the time they reach 28, have those conversations that Evan mentioned. Talk about if you feel comfortable your wealth. You can always talk about estate planning and things that you've done without dropping any numbers. Your kids never need to know how much they're going to inherit. Also encourage them to continue these conversations with their own kids. Make sure these morals are multi-generational. Tell them how this money was earned and the sacrifices that you made to get there. Remember, this is your legacy, and those kids better remember it. So focus on values, emphasize the importance of hard work, contributing to society, and not relying solely on inherited wealth. Open communication, and discuss your expectations and concerns with your children throughout their lives to foster a healthy relationship with money. And if that doesn't work, just do a really strict descendants trust and limit them to $5 a month. So you can always disinherit people, don't forget that. So with that in mind, we are going to take some questions. We won't have time to take everyone's question today. There is a link in the chat box to schedule an introductory call to see how we can help you with your unique services. And I am going to go ahead, turn off our presentation here. You can see me and Evan, and we are going to take some questions. So the first one I have is, how do I pick a trustee? What makes a good candidate for someone to help preserve my wealth if my kids are young? So I went over this a little bit earlier. Choosing of a trustee can be a very hard decision. It can be very personal. I will say just on a basic level, a trustee does not have to be the most financially sophisticated person that you know. It generally just has to be someone that you trust and someone that knows when to ask for help. Because a trustee can always look towards their own professionals, their financial advisor, their CPA, their attorney to help manage the trust. So someone with good morals against someone that you trust knows when to ask for help. Another question, I think, Evan, this one will be for you. How do I know which stocks are best to gift?
Yeah, thank you. And Alaina, I will go back to your question as well about the private foundation versus donor advised fund to get that kind of straightened out. I made a joke, but it was a finance joke. Um, the private foundation is going to be more expensive to set up, basically. Is it, at the end of the day, what happens? We have to get some lawyers involved. We have to do other things. The donor advised fund is like setting up any type of account or setting up a joint account. It's very simple. We can do it on our platform as well. It just makes it a lot cleaner and consolidated. Now back to the Q&A. Which stocks are best to gift? There is, again, it depends, the lawyer answer or the financial advisor answer, as everybody likes to make fun of me for. But we really want to look at appreciated stock. So that means stock that has a low cost basis or stock that you've bought for a little amount of money that grew to a large amount of money. We can take the most amount of tax benefit when we gift those stocks that have a large capital gain than if we sold a stock at a capital loss, because we can use that to be tax efficient in other manners. And so I think a good rule of thumb is if the stock has appreciated a lot, it's probably a pretty good candidate for that.
Well, thanks, Evan.
Yeah.
Last question. I'm going to take this one because I like it a lot. You two seem like a good team. Would my estate planning attorney work with an advisor? And the answer is yes, resounding yeses. Attorneys, financial advisors, CPAs, not only are they good to work together for you, they're also a really good team of advisors to set up for your children. You know, those people, that group that if something happens to you unexpectedly, your child knows who to call, your child knows who to trust that can step in and help them take care of things. So that's why Evan and I are such a good team, and why, you know, any advisor at Savant would gladly work with an estate planning attorney. So thank you guys so much for listening us today. I hope you got some good tips and ideas for preserving generational wealth.
Awesome. Thank you, everybody.
Thanks. Bye, y'all.
If you enjoyed this webinar, visit savantwealth.com/guides and download our complimentary guidebooks, checklists, and other useful financial resources.